Great. So hello, everyone. Thank you for joining us. My name is Kelly Weiner, and I'm the managing attorney at Scott Legal. If you're here today, you may already have some familiarity with the EB-5 green card, or this might be your introduction. All of you are in the right place. Our firm has a focus on investor visas, including non-immigrant investor visas and immigrant visas, such as the EB-5. Today, we'll be discussing how to obtain an EB-5 green card. A few things before we get started. This webinar is part of a series that we will continue doing. We will do at least 2 webinars a month on various immigration topics. We already have a number of webinars scheduled, and we regularly add more on our website. Also, at the end of this webinar, we'll send out a few things. One is the PowerPoint from this presentation. Another is a link to where you can sign up for additional webinars. We'll also send an EB-5 guide, and this webinar is being recorded, and we will send you a link to the recording. A few housekeeping items. We plan to reserve a few minutes at the end for questions, but we'll also respond to questions throughout the presentation. If you have a question, please send it to me through the Q&A or chat box. Again, my name is Kelly Weiner, and I will be the moderator for this webinar. We're fortunate today to have Ian Scott here to speak with us. Ian is the founder of Scott Legal and the executive managing attorney, and has processed many EB-5 successfully. So I will turn to Ian to get us started with the discussion of the EB-5 requirements.
Great. Thank you very much. Thank you very much, Kelly, and great to be here. And, before we jump into the requirements, let me just talk a little bit about some of the changes in this program. So there was a big change in the EB-5 program in March of 2022. And there's a little bit of history even before that, but I think that probably the more relevant part is when they developed the kind of the new law or updated law. And what they did is they made a number of changes, and some of these changes we're going to go over during the presentation today. But that, those changes really will set the stage for at least the next 5 to 7 years of the EB-5 program. So in terms of when we think of EB-5, we are always thinking of kind of 2 distinct paths. So one path is a regional center path, and the other is a direct investment path. So when we think of a direct investment, we think of an entrepreneur who wants to start his or her own business. They want to invest capital in that business. They want to, buy equipment, get the business up and running, ready for operations, hire employees, and they want that. They generally want that control to be able to do that. So really, that's and that really describes the profile of someone who is doing an EB-5 direct investment. Now, the regional center program is quite different. Now, what this is, while the direct investment program is very, very active, the investor is very, very active. In the regional center program, the investor is fairly passive. So a good example of a regional center program might be where a group of individuals are trying to build a large hotel, for example, and they want to raise a large amount of capital, say $100 million they want to raise. And then they ask people to participate in this regional center program where they will contribute or invest a certain amount of money. And there's a lot of documentation behind that, but really they are fairly passive investors. They will get a very modest return. They will have some voting ability, but not in any meaningful way. They will pay the regional center an administration fee, sometimes as much as $50,000, to cover all of the different things that the regional center is doing, whether it's marketing or administrative costs that the regional center has for their employees, et cetera. The investment here is like any other investment. You are given, in most cases, you're given a limited partnership unit, but it would be similar to buying a stock in the stock market. So there's certain risks associated with investing. And if you contrast that to the direct investment program, where you have a lot of control or more control with respect to, there's obviously risks in that as well, but a lot more control over the operation of your business. One other key distinction between the regional center and the direct investment program is that for the direct investment program, you can only count actual jobs. And we're going to talk about the specific job requirements a bit later, but you can only count people that you have hired. Whereas under the regional center program, you can count what are called indirect jobs. So in that example that I used, where let's say that there's a hotel that's being built, you can get, or the people who are developing that hotel, they can get an economist to write a report to say, well, the hotel is going to be there. And as a result of, they're going to be direct jobs, so jobs where, they're going to need a manager, they're going to need a reception, they're going to need cleaners, et cetera. But also they're going to be indirect jobs because by the fact that the hotel is there, there may be a dry cleaner next door, there might be a mall next door, or there are going to be people making deliveries. So there are all of these kind of, we'll call them indirect jobs that come out of the fact that the hotel will be there. And those can actually be counted. And in a lot of cases, they make up a significant portion of the jobs, because when you think of EB-5 at the kind of most basic sense, it has two fundamental requirements: one, that you invest money, and two, that you create jobs, right? So if this job creation can be done, based mainly on these indirect jobs, it's sometimes a little easier to do. Perfect, and we can advance to perfect. So now we'll go to the crux of the EB-5 requirements, and really, as I said, the kind of two big things here, and that's investment and job creation. Now, the investment is either going to be 800,000 or 1,050,000, and that investment has to be made in what's called a new commercial enterprise. But that's not a new enterprise, like new in terms of recently formed. But instead, a new commercial enterprise is defined by the statute, and I can't recall the exact date, but it's an enterprise that is started after 1990. I think it's November 1990. So the money has to be invested in the new commercial enterprise, and the difference between the 800,000 and the 1,050,000 depends on whether the enterprise is located in what's called a targeted employment area or a rural area. So a targeted employment area is defined by an area where the unemployment rate is 1.5 times the national average. And then a rural area is going to be defined by local government with respect to population. So much lower population than an urban area. Now, one of the big changes in March was that March of 2022, and as we go through these, I'm going to talk about some of the changes, was that in the past, the calculation of a TEA, so for example, regions that are where we can say that the unemployment rate is 1.5 times the national average, that determination no longer can be done by individuals, though that determination can exclusively be done by the US government now. So that significantly curtailed the ability for some projects to fall under this lower investment, this lower investment amount. Now, one thing I will say though, is that the investment amounts that I just went over, that was another big change that was made in March of 2022, because before that, the investment amounts were 500,000 and $1 million, right? So quite a significant difference between what was a TEA and what was not. But now you see that the $1 million just went up $50,000, and the minimum amount went up $300,000. So they're a lot closer. So maybe not as much benefit as something being a TEA is in the past, because if something is a TEA, what you have to do is, let's say that, for example, someone is investing over time. So let's say that there's a business that someone is investing in and they don't contribute. And let's say, for argument's sake, it's in a TEA. And they're investing $800,000. Let's say that person invested $200,000 over a 4-year period. If they did that, then every single time they made that $200,000 investment, in order for this to qualify as a TEA, the business would have to be in a TEA at the time each investment was made. So you'd have to go to those 4 dates that the investment was made and check to make sure that the business is still in a TEA. So the unemployment rate was 1.5 times the national average. So that's something to keep in mind. And that, of course, that requirement doesn't exist if you're using the higher investment amount. In terms of investment that can be included, unlike E2, where we can include legal fees, we can include administrative fees. With EB-5, they're a lot pickier with respect to what can be included. And administrative fees, such as legal and accounting fees, cannot be included. So we always, would back those out. So if you were investing $800,000, you would have to invest $800,000, but the payment of these administrative fees would have to be separate. Now, that being said, although they have to be separate, you do still have to account for where the money came from for these administrative fees. And that was yet another change in March, Before March, you only had to account for where the money came from related to the investment, but now you actually have to account for where the money came from related to the investment and the administrative fees. The other kind of key thing to keep in mind with respect to the investment is that retained earnings doesn't count. So let's say that someone, for example, is running a business and the business makes $2 million, and let's say there's $2 million in profit. And then the next year they have that $2 million in retained earnings, and then they spend the $2 million on equipment and employees and different things like that. That $2 million is not investment. Investment is not profit from the business. It's not revenue from the business. Investment has to come from the personal funds of the investor. So that's something to keep in mind. The other thing to keep in mind with respect to investment is that the money has to be invested in the entity. So when we look at E2, for example, what would qualify for E2 is an example where someone purchases, let's say someone purchases a restaurant for $500,000 and they give the money to the seller. That would be a completely fine E2 transaction, provided the restaurant had some employees, but that would not qualify for EB-5. And the reason is that the money wasn't invested in the business. The money was given to the seller. So the money doesn't have anything to do with job creation. So in order for that particular example to qualify, the individual, what would have to happen is that an individual could buy a business for $500,000, but then they would have to invest an additional $800,000 or $1,050,000 in that particular business to be able to qualify for EB-5. And then just to carry that example through a bit more, if let's say that business had 5 employees at the time that it was purchased, none of those employees would count towards what we're going to talk about in a couple bullet points down. None of those employees would count towards the required employees for EB-5. So, definitely, when you're moving in particular from an E2 to an EB-5, it can become quite complex because some of the things that you included in your E2 investment, or even the very nature of the E2 investment, if it was done through some type of business purchase, and that could be a business purchase of shares or a business purchase of assets, could make it so that you're basically starting from scratch for an EB-5. Now, the other big difference between E2 and EB-5, and we'll talk about this in the context of source of funds, is that both visas have a similar requirement that you have to prove that the money came from a legitimate source. However, if we say that E2 is a 1 in terms of level of difficulty of this particular requirement, we would multiply EB-5 by 1,000, right? So the level of detail that you're required to pull together when you are looking at EB-5 is quite significant, and the examiners are quite exacting, and and it's going back a long period of time. So even if the funds came from from something that occurred 20, 30, 40 years ago, the government really doesn't care with respect to the availability of information. They, in essence, are saying you have to provide the information or they're not going to approve the EB-5. So that is a significant part of EB-5, and in particular, when you're looking at regional centers, it relates to both, but when you're looking to regional centers, if the regional centers already had approvals, then really the only thing we're examining for EB-5 for an individual investor is their source of funds. So that's what we're focusing on with regional centers. But the requirement is the same, even if you're doing, we do EB-5 direct investments all the time. And, you do have to show where that money came from. And very few EB-5 source of funds are not complicated. The majority of them are quite complicated. And the investment does have to be an equity investment. So it can't be kind of like a loan to an entity or something like that. It can be, unlike E2, there's no ownership percentage that's required. It can be 1%, it can be a fraction of a percent, but it does have to be some type of equity investment. Okay, so job creation. So now we are looking at the other big part of the EB-5 program, and that's creation of jobs. So you do have to create 10 full-time jobs, and they are full-time jobs, which means that part-time jobs are not included. You can't just take part-time jobs and add them together. There's a concept of job sharing, but we almost always, we never use it. I shouldn't say almost never, we never use it because it's a very complicated concept, and it's one that can be challenged if you submit the application. So you should think of this requirement as 10 full-time jobs, and the jobs have to be U.S. citizens or green card holders. So that's something to keep in mind. And that's when we're talking about these, we're obviously talking about direct jobs, but they have to be, so that's very important as you're going through the process. we always advise our EB-5 clients to use E-Verify, because the government is not going to accept that, well, the person gave me a fake green card. They're not going to accept that at all. They would say that that does not count as a particular job. So, and then we talked about this already, kind of this linkage to job creation, where there has to be a link between the investments and creating jobs. So you often have to look at the timing of the investment, because let's say the jobs were created before you made the investment, then those jobs actually wouldn't count for the purposes of EB-5. So what do we file? So for an EB-5 petition, we file an I-526 petition, which is basically showing that you've made the investment and that you plan to hire the jobs. And then we also file, and this is another big change in the program, is the ability to file the I-485 concurrently. So if the person's in the United States and the category is current, then we can actually file the I-485. And if they're not in the United States, then we're going to go through a consular processing process. And after the person has had the green card for 2 years, because first they're issued the green card as a conditional green card, then we have to file what's called an I-829 petition to remove the conditions on the green card. So those are, in a nutshell, the EB-5 requirements. And we're going to go into some of these in a bit more detail in some of the next slides. Okay, so we talked a bit about some of these, key changes to the program. And the regional center program, not the direct investment, but the regional center program, it's just a congressional thing that does have to be reauthorized. So when in March of 2022, it was reauthorized until September 30th, 2027. And the next bullet is just really getting at, there was a lot of confusion when the program paused, because I didn't get into a lot of detail before March, but before March, the regional center program was paused for almost a year because the Congress didn't reauthorize the program. But the new rules make it such that, and there was a lot of uncertainty with respect to adjudicating petitions because USCIS just stopped adjudicating petitions. But the new rules actually make it such that any petition that's filed before September 30th, 2026 will be adjudicated. So this was a great change. We talked about the increased investment amounts and the fact that TEA is only the government can do that. And then the other kind of big interesting thing that happened is that there were these carve-outs, these set-asides for EB-5 projects. And in essence, this is relevant in particular for Chinese nationals or nationals from India, because those two countries are oversubscribed and there are long waits for EB-5 green cards. So these carve-outs, basically, if the project is either high unemployment area, and high unemployment is the same definition that we used before, the 1.5 times the national average, or if it's a rural area or if it's an infrastructure project, then the individual will be able to file the I-485, or the green card category will be current. It's not a retroactive thing. So people who are, have already filed, this is all only for new petitions that are filed. So it's, definitely, we regularly utilize, I think probably the majority of EB-5 petitions that we filed this year, we've been filing them under this carve-out because we wouldn't be able to actually file the I-485 without it. Perfect. So so we talked about this as well, that this ability to file the I-485 concurrently, and that's great because if someone's in the United States, then we can actually file for work authorization for them, and we can actually file for travel authorization for them. And we talked about the source of funds extending to administrative fees. So before March, you didn't actually have to show where you got the money from for these administrative fees. And it's not that it's that much more difficult, but it is a bit of a pain because you have to start thinking about where the money came from the time that the fees come into, the time they start paying any fees to any administrative person, whether it's lawyer, accountant, et cetera. There was a clarification. What the government wanted to do is for loans and gifts, they wanted to tighten that up a little bit and say that gifts had to come from immediate relatives and things like that. But there were really no changes in this area in the March new rules. So that did not ever occur. So gifts are fine. If you do give a gift, you should make sure that you have paid, or whoever gave the gift has paid the gift tax. Loans are also fine as long as the security is not the business or the business assets. And there was some other changes related to having, if the regional center fails, because before, if there was a regional center and there was like a tornado and, the tornado destroyed the regional center, the person was just out of luck, right? There was no provision in the statute for any remedy whatsoever. And now there is some limited remedy provided there. Some other changes that aren't on the slide is under the direct investment program. Before March, you used to be able to pool investors. So you could say, well, 3 people are going to invest $800,000 for the same business. Let's assume it's in a TA, and then we're going to apply for 3 green cards. But now, unfortunately, there is only, the new law or new rule says that you can only apply for 1 green card per business under direct investment. So that was a big change big change. Another big change that occurred was, and again, this was not something that we used very often at all, but there was an ability to, if you didn't have the full investment amount, there was an ability to get a promissory note secured against your personal assets and utilize that promissory note as part of the investment. There was some other procedural requirements that had to be met for that to work. You had to perfect the security and do other things like that, but it was available, right? So in those instances, the person didn't necessarily have to come up with the full amount of the cash. However, that was eliminated as well in the March rule. So, and some of these are kind of changes that were a little buried in the fine print, but definitely important changes because they do make a difference, because there are definitely some people who utilize that in the past that can't be utilized now. So other considerations, EB at-risk investment. So, this is a good one to think about. There's a really great case that deals with EB-5. It's called Matter of Ho. And a Matter of Ho is often thought of as just a business plan case. But it's an interesting case. And what this investor did is he was investing in direct investment, like, starting a business. He opened up a bank account. He put $500,000 in the bank account. He provided USCIS with a 3-page business plan and didn't have one contract or one commitment, and said, I would like an EB-5. And it was denied, and he went to an appeals court, and the court wrote a long opinion saying, no, you can't just put money in a business bank account. The money has to be at risk, and which either means some of it's spent, but even contractual commitment. So it doesn't all have to be spent, but there has to be more than what Mr. Ho had, right? And then it also talked about a business plan. We talked about loans and gifts. We talked also about considerations with purchasing a business, how it generally does not work for EB-5. And as we talked also, how much do you have to own? It can be a fractional percentage. You can't have any guarantees. And this comes in the context of EB-5, direct regional center a lot, because a lot of our clients say, well, like, I want to see something in writing that guarantees I get my money back or guarantees I get a particular return. And that's not permitted for EB-5, right? You can't, it is an investment in a risky investment, right? So it has to be at risk in that context as well. And I think we talked about, during the presentation, I think we talked a lot about moving from E2 to EB-5, but just kind of listed there some of the differences. E2 has not specific, maybe some additional ones. E2 has not a specific investment amount. Whereas EB-5 does. Not all investment can be counted in EB-5. The link to job creation has to be there, whereas that doesn't have to be there for E2. If you buy a business, all of those jobs will count towards the general E2 job creation requirement. So yeah. So I think we do have some time, so we can actually go through this example. So we could put all of the, we could just put all, perfect. So this is just an example to kind of illustrate some of the concepts that we talked about. Now, so we're thinking of Helen, she had an E2 visa, and she got the 2015, and she purchased a business, for $300,000. The business had 5 full-time employees, and, she paid the lawyer $40,000 in legal fees. So the end of 2019, she took, she got $500,000 more as a gift from someone, and that person got the money from some money that they inherited from someone. And then also, instead of giving the money to Helen, they deposited the money directly in Helen's business bank account, right? Sounds like it's not a problem, right? When the money was invested, so now we're at 2019, there were 10 full-time employees. So she hired 5 since she bought the company, because remember, she had 5 initially. And at the end of 2019, she thought she wanted to pay herself some money. So she paid herself a bonus of $100,000, and after the company made some money. And then on January 1st, 2020, she applied for a green card showing a total of 1.8 million. She invested 1.8 million, 300,000 initially, the 500, and then the 1 million that she made in profit. And she also said, I have 10 full-time jobs already, so I've met that requirement, and I don't really want to hire anybody else. And then her business is located in an area where the unemployment rate is 7%, right? So let's talk about this. So let's talk about the last bullet point first. So the unemployment rate is 7% where she is, and the unemployment rate right now is very low. It's like 3-point-something%. So she is in a TEA. So she would qualify for for the lower investment amount. However, what we have to look at is whether she was in a TEA at the time the investment was made. So if the 300,000 qualified for an investment, which it doesn't, but let's say the 500,000, we would have to look at the time that investment was made, 2019, because this example says the unemployment rate is 7%, but let's say that's today, we'd actually have to look at in 2019 when the $500,000 was put in to assess whether or not, because every time the investment is made, any investment is made, the business would have to be in a TEA. So let's look at the first bullet point. So she was on an E2, she got an E2 and she bought a business for $300,000. So 0 of that counts towards investment, right? Because it was paid to the seller and it wasn't, wasn't invested in the business. Similarly, the 5 full-time employees don't count at all. And the $40,000 in legal fees doesn't count. She's going to perhaps have to show where she got the $40,000 in legal fees from when we talk about, in the context of EB-5, but the $40,000 doesn't count. So then the $500,000 that she received from a friend, now that is, going to be a complicated source of funds because the friend is going to have to show that they paid the appropriate gift taxes. But also, the government doesn't care that the friend inherited money from someone who passed away 15 years ago. You're going to have to, they're going to say, I want to find out where that friend got the money from. So extensive documentation probably related to that. Now, another big issue with EB-5 is the fact that the friend put the money into Helen's business bank account, because this petition would be denied just based on that alone. Because Helen never had possession and control of the funds. So USCIS would say that she didn't invest anything because she personally didn't ever have the funds. And EB-5 is very particular with this. E2 is not. EB-5 is very particular with this. EB-5 regional USCIS used to deny petitions where parents would give their kids money to invest in a regional center. And because they didn't want the kids to have the money in the bank account, because kids can be kids and take the money and spend it, they paid the regional center directly. And so they took the money from the parent, gave a gift letter to the child, and put the money and sent the money to the regional center. And USCIS denied those petitions, right? So that's a similar thing that's happening here. The money would have to go to Helen, and then Helen would have to transfer it to her business bank account. So Helen, she says that she invested, then the last kind of interesting point here is that Helen, at the end of 2019, so in 2019, the beginning of 2019, she invested, for argument's sake, let's just say that counted as an investment. Now, she gave herself a bonus of $100,000 at the end of 2019, and that's a big problem. We always have to look at any distributions that are made to the owner or the investor, because the government's going to say, well, you invested, let's say you invested $800,000 and you paid yourself $100,000, so you really have only invested $700,000. So especially when you're right at the cusp of what the investment amount is, you know, in particular with the direct investment, you have to be very, very careful with respect to distributions, because, you know, USCIS will come and add up everything, and, you know, it would be a basis for denial. So we look at, you know, she's not doing well. She, you know, the 300,000 doesn't count, the 500,000 doesn't count, and the million never counted, right? So the $1 million that she made in profit, that doesn't count. In order for that to count in a meaningful way, that would have to be paid to her. She'd pay taxes on that, have the money sitting in her personal bank account, and then reinvest it in the business, whatever was left, and then that could count as part of her investment. But yeah, it's a good example. It's a good example to go illustrate a number of different points with respect to EB-5. So the other kind of thing to consider with EB-5 is time. EB-5 petitions take a long time to be adjudicated. Sometimes the I-526 can take up to 4 years. And we often now will sue the US government and say that, you know, they're taking in the form of a mandamus petition. We have other webinars, and on our YouTube channel, we have some descriptions of mandamus filings and how that actually is done. But, you know, 4 years and after around 2 years, you can consider kind of suing the US government. But 4 years for a I-526, the I-485 might take another year or so, and then the I-829 is going to, I think it's probably a 5-year wait now in terms of how long it's taking. So you do have to kind of look at all, like, you know, if you're in the US, you have to look at your underlying status. Now, because of the change in March, you can file an I-485 to give you status. If your category is current, you can file an I-485 and, you know, file a travel and work authorization. But you do have to, you know, be cognizant of what your underlying status is during this long wait period. And, you know, and sometimes we do have clients that have parallel green card strategies, because the EB-5 is complicated, right? You get to conditional green card, you have to remove those conditions. And sometimes, you know, we have one client that was approved under EB-5 direct, but she's also eligible for a national interest waiver, likely. So we have been encouraging her to file that petition, because that's just filing the petition and you get the green card, right? So there's no kind of conditional period and no long waits and things like that. So, but planning, I think, is key with respect to carving out, you know, what you're doing over this period of time, because we do have some clients. We have one client, which is he's a Chinese national, and he filed before, so he doesn't get to take advantage of the carve-outs. But, you know, he's been in the US on a student visa for a long time. And it's becoming problematic because the wait is not improving, right? The wait times are not improving for the categories. And like I said, it's not every country, but for nationals from, in particular, China, and then India would be the number 2 on the list. And then there are some other countries that go in and out of eligibility or the visa category being current. So. Perfect. And I think that is it. Yeah, I think we're all set. And we don't see any, do you see any questions, Kelly? I don't think so.
No, it doesn't look like we have any questions. So I think we can close there. So Ian, thank you so much for sharing your knowledge and you know, providing all this great information. You know, I certainly, you know, learned a lot. I think everyone else did too. So we will close there. Have a wonderful day, everyone.
Thanks, everyone. Okay, thanks, Kelly. Take care.
Thanks.
Bye.